Today's training, no need to memorize everything I'm talking about. Uh, you obviously can always refer back to the PowerPoint, and when preparing your client's case, you have as resources the manual that we provide with samples and other explanations, the PowerPoint again, and myself and my colleagues. So at Her Justice, we stand with women living in poverty in New York City by working with pro bono attorneys who can take their cases, particularly in the cases I work with in immigration matters, but also at our office, family law and divorce matters. Some of the objectives, the things we hope you come away from today's training today with. Learn why adjustment of status is so important to your client. Become familiar with the legal basis for U adjustment. Understand the evidence that is required. Obviously know the steps. You got to know what you're doing, right? And then learn how to work with, interview, and advise your client throughout the process. So this is what we want you to know. Again, I'm going to throw some jokes in there every now and then, but there is no need to memorize the information provided, right? There will be a few questions here and there during today's presentation, but again, no one is graded. Her Justice really, I can't claim that we're the first ever to do it, but we're definitely among the leaders in New York City. We began this model in the early 1990s through the collaboration of our first executive director with many of New York's leading law firms, and bringing together lawyers to really expand on how many clients can be represented if you really bring clients to firms versus just like our 14 in-house lawyers representing as many clients as we could. In the past, we've mentored over 2,000 lawyers. We're serving over 8,000 women and their children. And sometimes firms will ask us about hours, how many hours we estimate a case will take. And so we're giving you some of the information about how many hours have been donated by firms, our total partners. And so it's really important for everybody on the call today who's going to have contact with one of our cases and represent a client, who we serve, who Her Justice is here to serve. We obviously, as I was suggesting before, we serve individuals in New York City who identify as women and who earn below 200% of the federal poverty line. We are willing to be flexible on that. As I think everyone's aware, with COVID, a lot of people lost their jobs. And so how you kind of come to the 200% of the federal poverty line and how you look at someone's income can vary. And so just for the sake of understanding of who we serve, what do you think the federal poverty line is for a family of 3 in 2020? Okay, and yeah, the first, I see the results. We're pretty close to, 2/3 have got the correct answer being 21,720. So, yeah. And then for our second poll, in the US, women are what percentage more likely to be living in poverty than men? All right, we're getting there. Yeah, and it looks like pretty much everybody has the correct answer of 38%. It's okay. You know, obviously it would make sense why you choose either answer. All right. So it's, yeah, 82% of women are more likely to be living in poverty than men in the US. Thanks, Mike. And so just to understand who we represent, again, background of our clients, at Her Justice, 55% of our clients are born outside of the US. That doesn't mean that 55% of our cases are immigration cases for last year, but it does mean that many of our clients have immigration concerns or had immigration concerns in the past. And really, so many of our clients do not speak English as a first language or English sufficiently to access the legal system. So this is just, you know, an important way of understanding who our clients are and where they come from. And you know, a common misconception of our organization is that we are a domestic violence first organization or intimate partner violence first organization. That's not necessarily the case. So you don't have to be a survivor of intimate partner violence to be represented by our office. But 75% of our clients are survivors of intimate partner violence. Really, you just have to identify as a woman, live in the 5 boroughs, earn under 200% of the poverty guidelines. But most, if not all, of the immigration cases that we end up working on in the specific immigration unit that I'm a part of, our clients are applying based on a form of intimate partner violence or gender-based violence. So we're talking about U visas, VAWAs, T visas, battered spouse waivers that are a part of conditional residence. And so what is intimate partner violence? And this is really a chart that we like to come back to that you can use as a tool in other immigration cases. I don't think it'll be as important for you adjustment, but it's important for you to understand in general. Like when we're trying to show immigration, say in a case where we are saying our client suffered violence at the hands of their partner, and if it's okay, there's no physical abuse, and so we're trying to show like extreme cruelty, we're trying to show other forms of abuse or violence, we look at this and role and power over our client. So a lot of times I've gone back to this and just sort of tried to think about my client's story in context of this power and control wheel that so many advocates and attorneys use. And so trauma is very important to understand. Many of your clients will be years removed from the qualifying crime that was a part of them obtaining U status, the U visa. But it's important to understand trauma, just to understand the long-lasting effects it has on somebody's physical and emotional well-being. So it's good to review this and come back to it to consider how trauma may still be affecting your client when you're interacting with them, as far as timelines, as far as responsiveness to your calls, as far as responsiveness to you asking them for certain documents or figuring out very fine-tuned parts of an application. Don't directly assume that your client is being resistant because the client doesn't like you or the client has other priorities. But again, it's good to understand that clients do have a lot of other things going on, particularly in this time, but really, really consider trauma. But again, don't assume trauma is the reason for everything. Yeah, I mean, memory won't be as big an issue in this case. Really, what a lot of the U adjustment work with the client ends up being is completing the forms, making sure things are consistent with the old submitted U visa petition and the inadmissibility application. What you're going to be working with the client primarily, I mean, beyond all the filling everything out and completing what you have to complete, is sort of brainstorming about evidence that shows 3 years of continuous presence in the U.S. We're going to get to the requirements in a second. But there may be issues of, okay, there's still a joint account with the abuser, or there could be gaps in memory as to, like, I don't know what happened to those report cards for my kids, or I don't think I've been to the doctor in 3 years. But just sort of like working with clients, if dates are an issue, like, do you have any evidence from the start of 2017 or the middle of 2017? They can't really remember, and just sort of like talking about, okay, how old was your oldest child then? What was your oldest child doing? Try to walk through what the child was doing to sort of like backwards think about what kind of documents might be available to your client. You know, here's some tips about working with trauma survivors. Again, it's important to remember, and you can watch the video that we have listed there below. It's hard to say for each individual client how much trauma is still going to affect their lives. Some clients may not show any effect in how they respond to questions or present in a conversation or a consultation or a meeting with you. Survived, coupled with or layered with what is going on with coronavirus. They could have gotten sick, their kids could have gotten sick, they could have lost a loved one, they could have spent time in a hospital, it could have exacerbated anxiety or other mental health concerns. So it's just always important to think about trauma and how it's affected your client. But again, not just your client, also consider you know, having to review the details of your client's case, how that could really provide secondary trauma to you, the attorney, or the summer associate who's supporting the attorney on the case, and really think about, you know, hearing some of the really horrible details of qualifying crimes, and really the relationships and the circumstances that led up to those qualifying crimes. And it's okay to acknowledge that if you have to take a break, you know, you can talk to people at your office and say, listen, you know, I need a breather. I'm going to take a longer lunch than usual. And really, you can also talk to me about other ideas about how to try to, you know, other ideas of what to do outside of work to not focus so much on the case. So working with your client, I already alluded to this, coronavirus, COVID, everybody knows what's going on. No matter if you relocated to New York for your summer associate position, or you're doing this remotely, or everybody's got different circumstances. So, you know, try to, when you first speak to your client, sort of figure out what's available to them, how you'll be in contact. You know, try not to mix in like phone, email, WhatsApp, etc. Try to say like, all right, we're gonna go by phone. When's the best time to reach you? What do you have available at home? Do you, I mean, you know, it's not a requirement, but you can even ask clients, do they have printing access? Do you have a cell phone that can take pictures so you can send photos to me? You know, be patient. A lot of clients are going to be home with kids. A lot of clients might be working as well, have odd hours, and really want to hold on to that job. And really repeat things and make sure clients understand what you're talking about, and understand the circumstances of your client's life, the home environment, the work environment, if there's financial concerns, which there likely are. And again, as I am learning, as everybody is learning, during remote work, you know, try to set boundaries and be aware of how you're doing and how your client is doing. There's no perfect way to do it. We have a part of the manual, Working with Your Client Through Heard Justice During COVID-19, that talks about very real considerations of what immigration, USCIS, what they are allowing, like they're allowing copies of signatures and other things like that. And then we have some other tips in there about how to get around issues. But really, than I thought it would. Of course, work as promptly and efficiently as you can, but understand that what everybody is doing is not normal. One of my colleagues very wisely said recently, it's not that everybody is working from home right now, it's that we're at home and trying to work at the same time amid a global health pandemic. So these are some things to think about before you speak to your client. You can review it again after you talk to your client. You think about strengths and possible, I wouldn't say weaknesses, but areas for potential growth, right? Your client is very resilient and strong. They know what they need in their lives, and could have very stressful life issues outside of what you're doing with them. You obviously are very dedicated, very smart. You have a background in the legal system, and you have an ability to navigate the systems of immigration to help your client, become a permanent resident. Now, a challenge your client may face is having little knowledge of legal processes of the immigration system. Sure, they've been through it maybe once or more, but they're greatly served by having summer associates and then associates at firms and maybe a partner at the firm working on the case in conjunction to sort of navigate this system. Challenges you're going to face likely, unless there's people on the call who I'm not familiar with their background, where they have some experience in immigration law. Most people are going to be new to immigration law, or particularly U adjustments. And so I'm just going to try to run through what the U non-immigrant status is. I've referred to the U visa. The formal name is U non-immigrant status. That is what everybody's client has. And Mike's just going to check to see if you're still here. Great. So it's important to know what your clients have and why they can apply for a green card. And then also, I'm just going to give you a short primer if you have no familiarity with what the immigration system is. Again, you don't have to know it when you sit down. It's not like the client's going to ask you, okay, explain to me the acronyms for all the immigration agencies that exist. But it's just for you to understand and have context about what you're doing. And so, you know, I wanted to pose a question as we go into this. There could be folks on the call who've applied for immigration status for themselves, or they have no familiarity. What it's USPS, INS, USCIS, or DOI? We love our acronyms in immigration. We even use acronyms for things outside of immigration agencies. So I'll wait a second. Yeah, and it looks like about 2/3 of everybody guessed correctly. It's USCIS. Up until 2003, it was INS. But in 2003, INS was broken up and really folded into the Department of Homeland Security, USCIS being the agency within DHS. So we'll get into all the fun acronyms in a second. So yeah, who doesn't love a nice flow chart? So Department of Homeland Security, like I just referred to, is sort of like the overarching agency for many, many things in the US. Primarily what we are dealing with, what you are going to deal with, what I deal with in my day-to-day work is USCIS, or for even a shorter acronym, CIS, Citizenship and Immigration Services. Under DHS, there's also CBP. Those are the officials at the airport and along the Canadian and Mexican borders who decide if somebody can come into the country or not. Obviously, it's a little more complicated than that. And then I think a lot of people might know of ICE through the news or through their work or other experiences. Immigration and Customs Enforcement, in shorthand, are the immigration police. They look for people internally in the United States who are either violated their status or have a serious crime that triggers removal proceedings or do not have status. So you probably have heard of ICE raids. So again, you don't have to know what all the other acronyms mean, but it's just good for you to understand how everything has changed after 9/11 and how the federal agencies have morphed. So the current political climate, you know, I could sit and give a 3 or 4 hour presentation about that. I think if anybody watches the news, looks at the internet on their phone or social media, I think, you know, I'm going to assume most of the participants today are pretty informed about what's going on. As we have a president who campaigned on a platform of, among many things, it was hard to sort of like figure out what it was, but one of the main campaign points were that if you're born outside of the United States, the president and his supporters were not big fans of persons born outside the U.S. And so I'm trying to steer away from being political because obviously that's not the point of today. But it's no surprise that the people put in charge or promoted push forward policies that have been very negative to immigrants and applicants for different immigration benefits. There's new memos out that we have to deal with, it seems like almost on a monthly basis. Really the big changes are summarized in your manual, so it's good to look at that and review that, the early exhibits, I think 1 and 2. Primarily what's important to know is there's 3 huge changes. Everybody is talking about public charge. Maybe you've never heard of that if you've never worked on an immigration case, but essentially the government expanded public charge, which is saying you're going to have an immigration problem or inadmissibility if you receive this broad range of public benefits, or even now if you're trying to come to the US or obtain your green card and the government can show that it's likely you will become a public charge or you will depend on the government for support. Luckily for everybody on this call, so that you don't have to worry about that for the sake of your client, public charge does not apply to people with the U visa or applying for adjustment of status based on the U visa. So public charge is not a concern, but it's often talked about. Also, there's the NTA memo for the last 14 to 15 years of my career. If you applied for a U visa or what preceded that, or a VAWA petition or other humanitarian forms of relief to the Vermont Service Center where the applications for your clients will go, if the application were denied and all appeals were exhausted, immigration would not refer that person unless there was some serious national security or other issue to deportation/removal proceedings. Well, the government was able to change that rule in the last 2.5 to 3 years, which I don't think is a coincidence based on who's president. And now, for instance, if you apply for a U visa and several years down the road, if it's denied and the government can tell you're here out of status, they can put your client into removal proceedings. That is also the case with if you're applying for U adjustment of status, so the applications you'll be working on. But there's a way to appeal a denial, and there's other options if the case is denied. But it's important to know that there's like higher stakes. But all of your clients, it's way more beneficial for them to apply for this benefit you're helping them with than just to not apply and to fall out of status. The other big issue that's come up is what we call the RFE memo, that if you send an application to immigration without the initially required evidence, so if you just send what's called like a skeletal application with almost like no evidence, the government has the right now to just deny it without asking you for more evidence. So there's been a lot of changes within the system. You'll see a lot of the changes on the news about asylum and other things in immigration court, but it is a very hard time for our clients. And honestly, questions are going to come up in all your cases where you're not sure and it wasn't covered in the PowerPoint or the manual. Certainly review the materials you have, but feel free to ask me or the relevant how to respond. So here's some of the acronyms that you should be familiar with. Adjustment of status, AOS. We've already gone through some of the acronyms. EAD, I'll probably use a million times in emails. That's the employment authorization document, because you're going to be helping clients apply for permanent resident status, but also apply to renew their employment authorization document. The INA is the authority for all immigration matters, the statute. LPR, permanent resident. USC is not a university in California. USCIS, obviously the agency we went through, and then a lot of times I'll refer to VSC. That is the immigration office up in northern Vermont that you send the application to and that we wait for a decision from. And then, yeah, examples of immigration status. You don't have to memorize this per se, but it's just for you to understand what some of the differences are. A lot of people are in the US or come to visit the US as non-immigrants, and that includes U non-immigrant status, which is a U visa shorthand. Some of these you can transition from to adjust your status to that of an immigrant or lawful permanent resident. Others, it's harder to do without another independent basis. And then after somebody becomes a permanent resident, depending on how they did, what the basis was, you can apply for naturalization to a US citizen, again, not the university. The background of the U visa, U non-immigrant status really became a reality in 2000 with legislation, and really the intent, and this is the result of years of advocacy of attorneys and non-attorney, non-legal advocates to provide immigration status to persons who are victims of crime in the U.S., but aren't necessarily like married to the U.S. citizen abuser. So to sort of like expand the scope of what's possible for individuals in the United States. And it strengthens law enforcement in that it really makes undocumented victims of crime much more likely to be willing to report the crime and cooperate with law enforcement. And really law enforcement throughout the country really see this as an incredibly important tool to working on crime prevention, crime reporting, and prosecution. And so what is non-immigrant status? It's temporary status. So it's typically granted for 4 years. You can extend it if needed based on certain circumstances. It grants important rights to non-citizen victims of crime. There's a statutory cap of approvals, and this is important because U visas per year. Sounds like a lot, but there's currently, I think, more than 200,000 principal applications pending. So if you made the assumption all of those would be approved, which they will not, you could argue it'll take 20 years to get a decision from now. That's not the case because there's a much higher percentage of denials that change year to year. So you talk to 1 million attorneys, you'll get 1 million opinions. A lot of attorneys say, oh, it'll take you at least 5 to 10 to maybe 15 years if you apply today for a U visa decision. So all of the clients you're meeting with already have their U visas. I think typically many of them waited between 2.5 to 3 years for a decision based on when they applied. I think a lot of them applied in 2013, if I'm doing my math right. And really, non-immigrant status, it's kind of a hybrid sort of non-immigrant status because so many, like, if you just have a visitor visa non-immigrant status, you can't then say, oh, I'd like to apply for a green card or permanent resident status without other basis. And so it's very unique. I think it's relatively unpopular within the federal government right now because of the anti-immigrant animus that is being exhibited through so many words and actions. But it's an incredibly important tool to so many people. And it also allows many of our clients, it did allow, and it'll allow them in the future, reunification. So you can petition for derivatives. And so some of your clients might have done that. Many of the derivatives we see who are included, like if their kids are living in the United States and don't have status, who are under 21, or if their children are outside of the US and can then get visas at a consulate in the relevant country and fly into the US. So the requirements for a U visa, you don't have to know it for what you're going to do this summer, but it just kind of helps you understand how your client got to working with you and applying for adjustment of status. You have to be the victim of a crime, possess information about the crime. You had to have been helpful to the law enforcement agency investigating or prosecuting. It's often a big area of debate in those cases, but you need a signature from law enforcement saying that there was cooperation. The crime had to have happened in the US or violated US laws. Your client had to have suffered substantial physical or mental abuse as a result of the crime, and your client has to be admissible. And so there's different ways to show these things, but we don't have to get into great detail about that because that's obviously much more relevant if you're taking a U visa case, which you're not. You're taking a client on to represent who has a U visa and needs to adjust their status from the U visa to permanent resident status. So what is inadmissibility beyond this really fun graphic that seems like it was rejected maybe from Ghostbusters, I don't know, 30 years ago or more recently. Inadmissibility, as I think I phrased it earlier in the presentation, is an immigration problem. Very, very simple way of explaining it. Inadmissibility is a reason set into statute and regulation that would cause somebody to not be able to get, say, non-immigrant status, or even in the case of applying for permanent resident status, in most cases, they would be blocked from obtaining permanent resident status. Inadmissibility applied at the U visa stage for your clients. Inadmissibility does not apply for any of the clients you're going to be working with who are applying for adjustment of status. In U adjustment of status, and I'll go through this again, there are not grounds of inadmissibility. If something comes up or there's an issue from the past or something happened in the last couple of years, that is really just an issue of appealing to immigration's discretion and saying, please exercise positive discretion for my client. But common grounds of inadmissibility could be using fake documents, entering the country without inspection, not having a current passport, certain convictions, falsely claiming to be a US citizen, entering the country, staying for a certain amount of time, leaving or being removed, coming back without authorization. And so these issues should have been addressed at the U visa stage. If they were not, I can talk to you about how to address that in the application that you're working with your client on. Right. I don't want to go into great detail about this. It's just important to understand some of your clients could have just applied for the U visa and had faced no grounds of inadmissibility. They entered on a visa and overstayed, and that's okay for the U visa facts. And so they could have not required an application for a waiver of inadmissibility, but most of our clients did because they at least entered without authorization across the US-Mexico border or faced other grounds. And so there was an application, positive factors were presented, family ties to the US, etc. And so if new things have arisen since your client obtained a U visa, I can talk to you on an individual basis about how to address that, and we're going to go into that a little bit later in the presentation. A little bit about the timeline. Many clients, even your clients who applied for the U visa, they file a U petition, the red thing in the top left, and then many times, because that cap I talked about where they can only grant 10,000 U visas a year is reached for the calendar year, which starts October of every year, USCIS will grant an applicant who otherwise qualifies can last for a year or two and include work authorization. And then, as I said, for many of the clients you're going to be working with, maybe this whole process took about 3 years, and then they got a U approval. For most of your clients, that'll have been in 2016 or 2017. Have U non-immigrant status for 4 years, and then obviously after having it for 3 years, apply for the green card. And then, we're assuming if somebody gets their green card that they later on want to apply for citizenship. And so U adjustment of status is what we're here to talk about. It's something I've worked on for a long time, and it is incredibly, incredibly important for our clients. And it's just, yeah, I could talk forever about U adjustment of status. It's incredibly important, but like really to boil it down, it's important that it exists because what are we going to do? We're going to grant a U visa or U non-immigrant status to somebody who survived a horrific crime, suffered substantial abuse, cooperated with authorities. Sure, here's work authorization and status for 4 years, but that's the end of the road. You got to figure out something else on your own after that. No, you can adjust status after having that U visa for between 3 to 4 years. And so what is U adjustment of status, or I'm sorry, what is adjustment of status? Is it an oath of citizenship, elevated popularity, an approved attitude, or the granting of permanent resident status? And, upon review and talking about this question, perhaps I gave away the answer already, but maybe it's just like to see, how much y'all are listening. And, I like that, an improved attitude, because you're right, you could make that argument. But yeah, the correct answer is granting of lawful permanent resident status. So as I said before, and the question was answered, adjustment of status grants the applicant lawful permanent resident status. There's an example of a permanent resident card. and what it would look like. The category would be different. Obviously, a lot would be different on your client's card. That's the end result. That's what we're aiming for. Somebody can remain in the United States as a permanent resident for their entire life. It grants many benefits above and beyond having a U visa. It's continued employment authorization, but your client only needs this card to work. But now your client can travel without issue with their current passport from their home country and the permanent resident card. We generally advise clients, and we can talk about this at the close of the case, that clients only be outside of the country for a single trip for less than 6 months. Many clients laugh when we tell them that, because they say, look, I got a job. I can't leave for months at a time. I'll be gone for like a week because I haven't been able to travel in like 15 years. I want to go see my family in Ecuador. I want to go to China and see my cousins who I grew up with and haven't seen in decades. So there's the travel benefit is enormous. And then also, after having this permanent resident status for 5 years, clients can apply for naturalization if everything is in place, if all the qualifications are met. And there can also be derivatives at this stage of the application. So if your client is applying for U adjustment, they could potentially include a spouse who became their spouse before your client becomes a permanent resident, or other children under from your case opening report if that's relevant to your client. And we'll talk on a case-by-case basis if teams want to take that on, and if not, that's fine, and we can figure that out on our own later on. The immigration authority, like I said, why it's so important that people can adjust from that U visa to permanent resident status. That's what I often cite in my cover letter, 245M of the INA, or the regulations that are cited below. Fees are covered in the regulation listed, as are fee waivers. I think most of your clients are going to be applying for fee waivers because the cost of the application is a little bit over $1,200. That's a big lift for a lot of clients in regular economic times. I would imagine it's even harder right now. It's probably not going to be a surprise if some of your clients are not paying rent right now, or are behind on other bills, and are facing severe stressors as to food and other basics of life. So fee waivers, there's a special form that we use now. Technically, it's not required, and they even say it on the fee waiver site on the USCIS page. But in the last year and a half, it's another way immigration has sort of gone after applicants for immigration benefits and been very negative and unwelcoming, and that they deny what we used to use for so many of these applications. Very simple affidavits saying, I earn so much, I get this much support from my ex, my children receive these public benefits, these are my monthly expenses, please grant me a fee waiver, I have like no money to pay this fee. Now we have to use a formal fee, the I-912. And so I talked about this before, about what you're going to be working on with your client. So yes, filling out forms, there's an affidavit or two depending on the facts of your client's case. But what a lot of the evidence surrounds is continuous presence for at least 3 years in the US. So from the first date of the U non-immigrant status, the first date on their approval notice and their work permit, up until present, and then even through the application, but really until the time you file the application, you want to provide supporting documents showing that your client was continuously present. I get questions all the time, like, does that mean I got to show something that they were here every day? No, not every day. As a rule, we kind of say evidence for like every quarter of the year. And we really dig deep, and this is like a lot about a brainstorming and thinking with clients. We've gathered as much as we could in the time we had. You may have to gather more evidence with your client. So it could be kids' school records that list your client, your kids' medical records, your own client's school records, work records, pay stubs, tax returns, rent receipts, contracts of rent, et cetera, et cetera, et cetera. These are just some very basic examples. At least have written up and placed with firms, traveled abroad during U status. So I see the way I presented it, it might seem like, oh, you're required to have traveled, but I think almost all the clients you're going to be assigned did not travel. If somebody traveled when they had their U visa or U non-immigrant status and came back to the US, you want to show obviously the exit exit and entry stamps in their passport, proof of travel with airplane tickets, perhaps a print up from the government website showing their I-94 document for re-entry, but showing that they were not outside of the country for one trip of more than 90 days. And then if they made several trips, that they were not outside of the country for a total of 180 days. Because if you cross either of those thresholds, you will not be eligible for U adjustment of status unless you can show other extenuating circumstances. So just to come back, you're really going to want to spend a lot of time talking about with your client, like, we got to just pull together as many documents as possible. If there's not primary evidence, like the bills and receipts and stuff I'm talking about, we've sort of, you know, brainstormed and got U.S. citizen children, other friends or neighbors or coworkers, people who are comfortable submitting an affidavit to immigration to write up just a short thing like, I know applicant, I've known her for the last 15 years. We see each other every day because we're neighbors. I saw her every day for the last 3 years. It could be a simple affidavit like that. Something else, and this is a lot of this is tied into the affidavit that is supplied with the application. It's not a very complicated affidavit, but it's one of the other requirements for adjustment is that after cooperating in the criminal case and obtaining the U visa, the applicant did not unreasonably refuse to cooperate, like later on. Like if it was a long pending case, if it had gone to trial, and then later on in trial, the applicant had refused to testify or said, I don't want to cooperate anymore. That has never been a problem in one of my cases. And really, the way of showing that your client did not withdraw cooperation is just to include this in the affidavit, a sample of which you have in your manual. And I would not encourage anybody, and just don't do this, don't try to get a new U visa certification, like a new signature from law enforcement. That's not required. And if we did that for every case, it would be so much more work on the attorney's end. And then also it would burn bridges with law enforcement who are so cooperative and dedicate so much of their time to signing the certifications. If we're like, hey, you signed this for our client 7 years ago when she was applying for a U visa, now she's applying for a green card, could you sign again? And so it's gonna make them a little warier of cooperating and helping clients and victims of crimes out. Grounds at this stage. It's unique for an adjustment of status application. So since your client became a permanent resident in, let's say, June 2017, if they were arrested, if they used fake documents, if they robbed a bank, if they did something that would otherwise trigger inadmissibility in a case, or even if we're just talking about actions that raise inadmissibility grounds at the U visa stage years ago, the whole time we're appealing to USCIS to exercise positive discretion for your client. So, and how do we do that? We think about humanitarian grounds, family unity, or the public interest. And so many of your clients are not going to have these issues. One client that I can think of might, and if you have questions about it, you can talk to me, but essentially you're saying, look, there's this thing that happened. We'll talk about how to present it, because if it was like a criminal issue and there was an arrest, but then like say charges were dismissed or it was pled down, you don't want to say everything that happened. You can just say, I was arrested for X. The ultimate disposition was Y. This is what happened, but we'll talk about how to explain it. You don't want to admit more facts than need to be admitted. If there's really serious convictions, like we say for drugs or weapons or for seriously harming somebody, then there's going to be greater strategy sessions about how to present it. Family unity, obviously, I like to often include photographs of families together over the years, showing awards of children or your applicant for volunteering, for school, for different things. We have examples and ideas in our manual, but it's just, this is what you're going to spend a little bit of time doing depending on how serious inadmissibility grounds your client faced in the past, and if anything negative came up in the last couple of years. And so when do you want to file for U adjustment of status? You know, obviously no one's going to be able to file today, but as soon as possible. I think every client that is being assigned to a team on this call has had their U non-immigrant status for at least 3 years. So you want to apply between that 3rd-year anniversary, that 3-year anniversary of having U status. So if you got it June 1st, 2017, client wants to apply between June 1st, 2020 and May 31st, 2021. The way that they grant the status, it's not June 1st, 2017 to June 1st, 2021. It's still like a day before, the way they count 4 years. And so you have to apply within that window, or 3 years after the U derivative arrived in the US. Yeah. Nuts and bolts. This is covered in your manual as well, but it's just kind of like to get you thinking, to start client file, a case opening report. We try to give a brief summary of the U visa case, who the client is, where they're from, how they entered the country, how long they've had status, issues that have come up since they have their U visa, if they had to waive grounds of inadmissibility in the past, anything pertinent to know. Obviously, identification documents, the approval notices, any certificates of disposition for crimes, and then copies of the applications that were submitted. And that's incredibly important because you want to make sure to review that. And then when you're completing the I-485 form, and the different forms we'll go through in a second, you want to make sure that questions that mirror each other. Have you been arrested or cited before? How did you enter the country? Things that are asked in a similar manner on the 918 petition for the U visa, and then the form you're filling out now. You want to make sure that they are consistent. So you obviously have to ask the client those questions, but if an answer your client gives you now is different, maybe talk about and say, oh, well, look, on the old application it said this, why do you think it said this? And then if there's differences that can't be figured out with your client, we should talk and then kind of strategize. So it's good to review everything so you're familiar with the case, and then to make sure everything is consistent. And that's really a way to get started even before you talk to your client. This is the top half of a sample U approval notice. So for this client, for this example that we're using, she was approved November 29th, 2012. That's the start of her status. And like I said, the 4-year period is like, it's almost like 4 years minus a day. So up to November 28th, 2016. And then this is the bottom half. And on the bottom half of the approval, they almost have a tear off. It's like an I-94 notice. They grant that first date, November 29th, 2016, as lawful admission as a non-immigrant to the US. Admission can mean a lot of things. It just means that USCIS is granting them status in this case. Obviously, your client, or I think all the clients that are being assigned this summer, did not enter with a U visa. We've had some clients who obtained their U visa outside of the US because they had to leave, but they applied from outside the US and entered with their U1 visa. Or it's much more common, their derivatives entered with like a U3 or another kind of visa. And so their first date of valid status in the US is the first date they came in. Most, if not all, the clients assigned to the teams this summer, it's all like they were granted admission when the applicant was in the US. And so another question for you, I mean, I kind of gave you some hints and answers on different dates, but the applicant with the notice we just showed you, when should she apply for U adjustment? After her approval, so basically 2012 to 16, before 11/28/16, you know, so anytime kind of, you know, the 2 years before her expiration, or the last year of her validity. And yeah, I know this is tricky. I don't know if you're able to, on your own versions of the PowerPoint, to flip back to what the dates were, but again, the dates of validity, the status were 11/29/12 to 11/28/16. So the correct answer is obviously the last one, 11/29/15 to 11/28/16. So yeah, if you have questions about it, let me know. But again, the clients assigned to you are all going to kind of be in that important area, that important time period of the last year of U visa status when they should apply. So these are some sample questions on an older version of the I-485 application. If you don't understand some of the questions, let me know. The clients may not understand some of the questions. It's okay. You can kind of make a note and talk to me about how to explain it better. It's going to depend on trends that we're seeing. The immigration is pushing back on what they call incomplete U visa applications. So in the past on U visa applications and U adjustment applications, say like, there's a question like number 26, have you ever committed a crime of any kind, even if you weren't arrested? We oftentimes will answer that no, and then explain on the addendum in the last page of the application saying like, look, I entered the country without authorization in 1995. I don't know if that's a crime for which I was not arrested. Because the argument goes, obviously, your client is not an attorney, your client is not in the government, they do not know all the elements of a chargeable crime for illegal entry to the United States. And so I know it sounds like we're sort of lawyering immigration, but again, that's what we're trying to do, and that's what summer associates are getting to, is becoming a lawyer and answering questions as they are asked and not giving more information than what is asked. Sometimes with a question like 26, instead of checking off no, we just write like unclear next to it, draw a box and like have a selection of that. I think that's the way we're still going to go with it if there's an unclear answer. But I'm just going to keep my eye out for trends this summer, as are my colleagues, about if immigration is pushing back on answers like that for U adjustment applications. Again, I have to emphasize this just at this stage, but it's important, like when you're answering these questions, like have you been arrested? How did you enter the country? Have you ever used fraudulent documents to enter the United States? If that was all revealed and brought up at the U visa stage, which it should have been, when you're doing the addendum, like you're kind of like giving explanations for yes answers, like yes, I was arrested, this is what happened. You want to remind USCIS in that, like, I was arrested on this date, this was mentioned at the U visa petition stage and waived. Now, if there's inconsistencies, like I said, when you're comparing that U visa petition and your I-485 application, and say your client is answering something different or something new is being revealed that should have been revealed on the U visa, explain it and have the client, apologize and explain the inconsistency. And then again, if there are inconsistencies, like things that should have been waived earlier on that were not, in the client's affidavit, you want to really emphasize positive discretionary factors. Like, I have 4 children. They're in these levels of school. Their favorite classes are this. This is what I love about this child. This is why we're all so important to each other. This is my child's connection to the United States. These are the languages my child speaks. This is what my child is doing in college. This is the kind of job my kid has. So obviously, I'm really emphasizing family, but that's what immigration can really understand. That's something that's relatable to anybody. And so beyond that, volunteering, some of the other examples I've given, you can think of a million positive discretionary factors, but you're really going to want to load up on those if there's inconsistencies or you feel yourself and your client doing some explaining of stuff, of either new issues that have come up or things that should have been mentioned a long time ago. So
just checking in with the first code. For those of you who are looking for CLE credits, the first code is JN117. Again, that's JN117. Thanks.
Again, if this kind of stuff comes up, speak to me or speak to the relevant mentor for your firm. So one of my colleagues, Pratibha, Susanna, or Esther. Obviously, disclose it in the I-485. I'm never suggesting to not honestly answer a question. Again, it's all an art of how you answer the question, okay? You have to give the information, particularly in these contexts. But we joke in our office about asking too many questions. And so, like, if a client says, oh yeah, I never told the original attorney about my arrest back in 1990. I was a teenager. I thought, like, I'm a kid. It didn't really matter. They said my record think down the road, this client, if they adjust status, are going to apply for naturalization. Maybe they don't have to, but a lot of people do. And once you apply for naturalization, they really, really put you through a strenuous process. Like every application, strenuous, background checks, fingerprints. But the naturalization process is incredibly fact intensive. They're reviewing everything they have in the federal file about your client. And they love to catch people not telling them the whole story. And so you don't want somebody to end up in removal proceedings down the road when they're applying for naturalization because they're like, oh, I was a kid, I was 13, they said I wasn't an adult, so whatever. You know, again, it might become an ethical issue, but we rarely have that with clients. And if that does come up, let me know. And if something came up in the last 3 years, so since your client obtained their U visa in early 2017, and your client was, say, arrested for a DUI, okay, relatively uncommon in New York City, but arrested for something else, so there's another negative factor that you're going to have to reveal, be ready for a fight with USCIS. I'm trying to be even-handed, but we still have some allies within USCIS, within the humanitarian division, but I do feel like they've been staffing it with new people, and they've been training them very differently, and really trying to apply such a strenuous standard when people are applying for adjustment of status, when actually the standard is more strenuous at the earlier stage. And so they really, really are going to request every document about the arrest. We still advise when you apply, if somebody's been arrested, you just send a certificate of disposition. Immigration later on will write back and ask for other documents, and then we will strategize about what documents to give them. These are the forms you're going to want to fill out. We have a checklist in your manual that goes through this as well. The forms, we have listed on here the I-693 report of medical examination. That's still not initially required, and we're still advising for you not to have your client get that when you apply, because some of these applications, the time range is all over the place. They're listing like 10 or 12 months to 20 months. An I-693 medical examination it looks for grounds of inadmissibility. It's required for this application. But the signature of the doctor who does it, and you have to go to special doctors, and we'll tell you how to do that, is only good for 2 years. So for some reason, if your client's case drags on for 2 years, which it shouldn't, but if it does, then you'd have to get a new medical examination. So we say apply, don't get the medical exam yet. Once immigration gets to your client's file and wants a medical exam, then your client goes and gets the medical exam. They can usually do that within a week. Sometimes clients will want to apply for I-131. It's basically travel permission. It's a possibility, but it's relatively uncommon in many of the cases I've handled. But let me know if your client is interested in that. Now, the affidavit, I've been sort of like talking about in bits and pieces. This is a required affidavit, and the elements you're going to want to include. You're talking about continuous presence, and we have a sample in our manual. You refer to that, saying, I have been here, there's like a two-part thing. Like, I've been here since the start of my U status in June 2017. Overall, I've been in the United States since May of 1995. I cooperated in this case back in 2000 with the NYPD. And since that time, I have not refused to cooperate because the case is closed. If they came to me, of course, I would help them. Discretionary humanitarian factors is stuff we talked about. So you sort of like talk about all your clients' positives. And then if there's new negatives within the U status period, then you address it as skillfully as you can. And then an affidavit or certificate of translation. As for many of your clients, their first language is Spanish or another language. Supplementary documents, we've talked about this. These are some of the things you include. We have a sample cover letter, and you can look through that to sort of figure out, all right, I need you to include this, this, and this. A sample like index of evidence. So you're going to want to include ID documents, current passport, old passport, approvals, proof of continuous presence, proof of positive discretion, family photos, tax returns. Just come up with examples that I'm not giving you and that we don't give you in the manual, and I'd love to hear about them. Some of the distinctions that I've been talking about, There's no need for a waiver of inadmissibility if new grounds come up. We've already talked about how to address that. There's no affidavit of support or any other form you have to fill out about the affidavit of support. There's a specific question that pertains to that on the application. And, which many of your clients might want to know, which I believe we've talked to them about, but it's natural to ask this again, is there an interview? No. Many applications for permanent resident status involve interviews. These do not. It's all adjudicated on the papers. The hope is you send everything in, immigration in 10 to 12 to maybe less, maybe more months, maybe 15 months, hopefully not 20 months, they send approval. Now, second best is they send a request for evidence, as they probably will for a lot of clients, saying, send us the medical exam. And oftentimes they're saying, we need a better copy of the passport. We need more proof that you were here in early 2018. We need your whole arrest record for this arrest in 2019. But there's no interview. And so it's really, it's on the papers. Practical considerations, COVID-19, we have a whole exhibit about that in the manual, about changes in the practice and what you can do as workarounds to meeting with clients, so getting things signed. If you need things notarized, a lot of affidavits you do not need to get notarized, especially to send to USCIS, and we explain that. So obviously you want to meet with or speak to, whether over the phone, if they're comfortable with video conferencing and are able to at home in a private manner, speak to the client and derivative children who are over 14. Each applicant has to have their own application. So if there's a derivative applicant, so somebody who has a U3 status, the child of the original applicant, they need their own I-485 application. These are some of the requirements of what attorneys are going to do. Obviously, you're filling out immigration forms that you get from the immigration website. That information is available in the manual where those forms are. You want to make sure you have the current forms. You complete affidavits with clients. It's for even derivatives, and you file the application packet, and then you respond to correspondence from immigration, receipt notices, fingerprint notices. We need more evidence notices, which are called RFEs. Filing, it's okay to come back and talk to me about it, because I think some people probably want to have like a visual idea of what I'm talking about. How do we format it? You don't echo bind it. You don't put it in a fancy like plastic binder or anything like that that looks like something you would hand out at a meeting at your firm or your office. You have one packet per applicant. So the cover letter, the index, the application, the evidence, the affidavits, the I-765 application, photos for the applications. Everything is combined into one packet, and you do a 2-hole punch at the top of the packet and use fasteners to hold it together. For all the exhibits, for the different ID documents, for U visa approvals, for continuous presence, everything else, you want to use colored paper as exhibit dividers. Don't use tabs that show up on the right column on the side or below. You just want to use colored paper like A, B, C, D. Now we're checking to see if you're still here. Good. Thank you, everybody. And you know, it's important to understand the timeline. The receipt notice can come anywhere between 2 to 3 weeks to maybe a month. There's a receipt number in the top left. We have examples in our manual of what this looks like. It starts with the EAC. You can go to immigration's website and check the status. It often doesn't change too much, but we also recommend that you, on the case status website, there's a way of like creating an account for yourself where you can put in your client's receipt number so that you're also emailed anytime there's action on the case. If they send a notice, if they send an approval, you're going to know via email even before that paper notice shows up. Okay, and then maybe around the same time as a receipt notice or a few weeks later, you'll get a U extension notice, which is very important because it shows your client remains in U status, U visa status, while their application is pending. And that's often important too if the client's U visa status is about to expire and maybe their new work permit arrives weeks or months after the old work permit expired. So many people have jobs who are really on top of it. They're like, listen, your work permit, your EAD is expiring August 30th, 2020. If I don't have that, we're going to have to let you go until you get the new one. I can send you the memo separately if this is an issue for your clients. The U extension notice can serve as employment authorization, even without a work authorization, for 1 year after the expiration of the U work permit. So if there's that gap in time that I'm talking about, your client is allowed to use the U extension notice for proof on an employer's I-9. And so we can talk about this. It's very like in the weeds, and it's only relevant to some clients, but the U extension notice is very important. A biometrics or fingerprinting notice will arrive about a month after filing. I don't know, maybe a couple weeks more. That is really the only appointment your client will attend, and that'll be in the county relevant to their address. Most clients, it'll be in Manhattan, maybe in the Bronx, maybe in Brooklyn. The client can attend the interview by themselves. They just have to go with their ID and the notice. It's very routine. There's no questions asked that you need to prep them for. It's more like verify identity, wait in line, get fingerprints taken in a computer, get your photo taken for the application. That's it. The new work permit that is a part of the I-765 should arrive, I'm going to ballpark it 3 to 4 months after you filed. I think they put waiting times on there right now as 5 to 7 months. So be prepared. It could take a while. And that's why it would behoove you and your team to really work with the client as quickly as you can and efficiently as you can without obviously rushing a client or forgetting real life considerations at this time, to file as soon as you can. Like, don't say like client's status expires September 1st, 2020. We're going to file at the end of August. That's not a good idea for their work authorization. And then also if immigration rejects the fee waiver application, which can be an issue, they will reject the whole application and send it back, and then your client has to refile. You don't want to leave just a few days of status when you file. You want to file as soon as possible. I'll repeat this again in emails to you, but it's very, very important. And again, I'm saying you might receive a request for evidence for the medical exam or for other issues in the case. Once you receive that, months after you file, could be 5 months, it could be a year later, let me know immediately, or whoever your mentor is in my office, let us know. Say if I'm out on vacation or something for a day or two or a week, on my email and on my phone, it will be obvious who's covering for me at my office, and you can contact them directly and say, listen, Tim's out, I've been working with him on this case. Can you help me? I got this notice. What are we supposed to do? What are next steps? Okay. Everything you receive, we are happy to hear from you. Okay. Don't think that you're bothering us. The receipt notice, we would like to have that sent to let us know whenever you get anything. We'll tell you what to do. You may be the kind of attorney that reads the entire notice. You should. There's language on there that might be confusing, and we're happy to talk to you about it. Processing times are listed, as I said, between about 10 months to 20 months. Recently, I've seen many cases adjudicated in about a year. So this is like a timeline. There was a timeline before in the U visa discussion. If you're more of a visual person, you kind of understand things with, colors and graphics and stuff like that. Again, we say path to citizenship at the end. Nobody is required to apply for citizenship. We often recommend it because once somebody becomes a citizen, obviously there's benefits you don't have otherwise. You can vote. You cannot be removed from the United States. You can petition for your adult parents, or also for a spouse. There's different ways of petitioning for people. You can have jobs you can't otherwise have, in the federal government or law enforcement or different offices. And so it's just something to think about. But again, not every client will later on apply for citizenship. And even if your client that you help with permanent resident status wants to apply for citizenship, you are not required to do that. You're working on this U adjustment case. They could come back to your firm later on and say, hey, I really love working with X, Y, and Z attorneys or summer associates. You made such a difference in my life. But oftentimes they'll communicate with us first. If they communicate with your firm and your firm's not ready to figure that out and take that on, that's fine. You're not committed to. you just let us know, and then we'll talk to the client and sort of analyze the case. This is the application that you file at. If you've worked on a U adjustment case before, or you have old examples from your firm, there might be different attention to, like attention VAWA unit, attention CRU. Just if you're not sure, ask me, ask your mentor, but also look at the USCIS forms website, and it'll say like filing location, and you just look at this long chart they have of like based on what you're applying for, and this is where you file it. This is in the manual as well. Communicating with USCIS, they have online, they list average processing times. Like I said, the second bullet point here, you can sign up for case updates with your client's receipt number, so you find out immediately by mail when something happens. When you send the applications to immigration, to USCIS, you send it through trackable mail. We use FedEx just so you have proof that it arrived on a certain date. And then certainly during COVID or at any time, alert your mailroom of expected mail from USCIS, because I, as the mentor, the other mentors at our office are going to talk about like, no, like the client's mailing address, this is how you fill it out in the I-45. We have examples in the manual, you should follow those. But sometimes USCIS puts different information. They might just put your firm name on there and the client's name. Your mailroom should really be looking out. Before you communicate with USCIS, talk to your mentor, but here's some ideas. Like say if the case is outside of processing times or the receipt notice has your client's name recorded incorrectly, you want to, I regularly email the email address that's provided here. Don't use it a lot. It's not like to say, hey, what's up? What do y'all think about my client's case? It's more like if it's outside of processing time, there's other like grave issues in the case. You include identifying information, the attorney who is on the case. So maybe the summer associates are doing a lot of the work, but the associate or the partner at the firm who's on the G28, whose name is on the case, should send the email. The summer associates obviously can draft it for them, but like just so that USCIS doesn't write back and say, you're not on the case, we can't talk to you. So the response could come in a day from immigration. The response could come in a week. It could come in a month. It's all over the place. Or an alternative is to call the phone number provided, 802-527-4888. You leave a voicemail and they typically call you back within a couple of days. Recently, and this was pre-COVID, they would actually respond quicker to the phone calls. But if you do that with a phone call and you leave a message, we recommend you give like your cell phone number or a number that you'll be checking and the ringer is on, so that you're not playing phone tag. We also give the USCIS general customer service number, but don't call that. Don't. It's just, we put it on there just in case. If you're about to call that number, talk to me first. Communicating with us, like, so if you're sending us, obviously you're going to send us drafts of all the forms before you send them out. You're going to send us drafts of the cover letter, index, affidavits, especially the index to talk about, okay, what's all the evidence we're sending so we know what you're sending. Allow for half a week to a week turnaround time. Please don't send it to us signed. Don't send it to us signed by the client, because there's going to be changes we're going to want made. Again, you don't have to do what we say. The mentor relationship is not that we say and you do. It is more, this is from our broad experience in immigration. We recommend that you do this. Respect more than one round. We don't have to review it 5 times, but there could be things that we really need to get down and like hammer through so it's perfect. So it could be more than one time that things are looked at, okay? And then once you file the application, once it's in the whole packet that you 2-hole punched and you're ready to send out and it's scanned all together, send your mentor a copy of what was filed and then all the USCIS receipt notices and other notices. And this is how you communicate with your mentor during the case and prior to filing the case. Obviously, contact your mentor right away if any notice from immigration is received, but especially a request. Those are pretty uncommon for U adjustments, but they do issue. If the case is outside of processing time, so it's been pending for more than 2 years, hopefully not. If your client was arrested, or if there's staffing changes, particularly when the summer associates are leaving, and or if the associate or the relevant attorney at the firm is taking another job. These are some other, we talked about sort of realities of remote representing a client. But these are obvious things you want to do with your client. Provide your client with all the copies that you're providing your mentor with, obviously. And if possible, if mail is okay for them, or coming by in person, depending on what's going on with coronavirus at the time, provide your client with hopefully an original of all the filings and notices. They can attend the biometrics appointment with a copy of the notice. Explain what the notices mean. Clients would like to know. English is likely not their first language. Most clients that you are being placed are having placed at your firm. So explain what this means. This means immigration has your application and they're working on it. This means you got to go to this fingerprinting appointment. Provide the USCIS processing times. Okay, we're filing. I estimate we're going to hear something like a decision in your case or a request for evidence in 10 months to a year, or to 2 years. Sorry, could change. After the approval of the work permit, and we're going to see if you're still here. Wonderful. Okay, what's going on? All right. Good. After the client's I-765 is approved, they get the new work permit. That's good. It's granted for a year, but set a reminder, the attorneys on the case, set a reminder to contact your clients 5 months prior to the expiration. So if it's granted September 1st of this year, set a reminder for April of 2021 to contact your client to fill out a new I-765, because the case could be pending. The green card case, the permanent resident case, could be pending for a year to two. So they're going to need a new work permit after the new one you get them this year. You know, again, like I discussed, there could be issues where like one work permit expires, the new one hasn't arrived yet. And there's strategies about how to use that U extension notice and how to advocate with an employer. If your client has a job and they're in danger of losing it, being furloughed, et cetera, because of the gap in validity. Some employers are willing to be flexible and work with people. Some employers don't even notice. It's the employer's responsibility, not the client's, to verify that their employee is authorized to work. So if they're checking with your client, there's ways to work with the employer. Some employers are super nervous and they don't want to get audited and they're afraid of being in trouble with the federal government. That's where the forms are, the USCIS forms website. That's where you check the case status. That's where the processing times are. The immigration court phone number is automated. It won't be relevant really for most clients here. If your client has a removal order, we'll tell you in the case opening report. Again, the inquiries that I talked about in that previous slide, that's the email address. We like that because it kind of creates a paper trail. Obviously, in the client's electronic file, if you're using that 802 number to call instead of the email address, you want to make a note of it and summarize the voicemail left and what immigration says when they call back. But again, if anything else, rely on your mentor and the manual. The manual has examples of everything. It has a checklist of what you have to send. It has reminders. It has what to do during COVID. It's really exhaustive. And if you have suggestions for improving it to make it more user-friendly, I would love to hear. I and my colleagues, we don't have big egos about it. We just want to make sure that we're serving the firms and the teams that work on these cases who serve our clients. You know, the mentors, my name's on top there just because I'll probably be mentoring, I think, most of the people on this call. I think I knew a little while ago, but my memory is escaping me. I think some of my other colleagues are going to be mentoring some of these cases too. You'll know ahead of time, like when the case opening file probably already has arrived, it's going to say who your mentor is. This is our contact information. We're obviously all working from home. We're not in the office, but you can leave us a voicemail. We get an email about the call. Many of us have calls forwarded to our cell phones. We can still check the voicemails. We're going to know that you called. Email might be a little bit better for communication, but we can set up conference calls because obviously it's more helpful to talk through some issues regarding these cases. So thank you. I think we have a little bit of time for Q&A here at the end. I would just say in closing that this may seem like a requirement that you have to do while you're spending your time at a firm as a summer associate. But I would hope that most people working on these cases who are law students right now and working with the firms are excited about this, whether it's your first contact with the immigration system or if you've been personally involved or you've had friends or family or you did immigration work before. the effect that you have on somebody's life in doing this kind of application and representing a client and helping them navigate this system. Like I said, the benefit of becoming a permanent resident and being able to travel, a lot of people are so interested in that, and seeing their parents who they haven't seen in years, or just visiting friends and family, and just having that freedom that so many people born in the United States or with regular immigration status that allows travel take for granted, in being able to leave the United States and travel back and forth. Might not be a current reality. A lot of people aren't traveling, but just to have that right once coronavirus is figured out and once everybody can kind of get back to life as usual. So thank you. You're really making an incredible impact on your client's life. And I'm always open for questions. Thank you.